Number 14, matter of O'Donnell versus Erie County. Good afternoon, counsel.
Good afternoon, Your Honor. I would like to request 2 minutes for rebuttal, please.
You may.
May it please the Court, my name is Matthew Hoffman. I represent the appellant Erie County in this matter. First, as an initial matter, it must be noted that I think all parties are now in agreement that the particular board decision subject to an appeal is inconsistent with both the board's prior decisions and its subsequent decisions addressing the nature of the permissive inference outlined by this Court in Zamora. Therefore, the simplest and the most logical explanation for this Court to remand the matter for the board to either A, issue a decision consistent.
Was that argument preserved below?
Well, at all stages, the employer has pointed out that this decision is inconsistent with the board's decisions addressing the nature of the inference. So I would say yes, by outlining to the board panel and to the appellate division that the board, both before and after this particular decision, had rendered inconsistent decisions, I would say yes.
Why do you say it's inconsistent with Zamora? As I understand Zamora simply corrected a misguided strain of Third Department law and went back to the prior consistent strain that said the board may, but does not have to, make an inference. Is that the correct understanding of Zamora?
That is correct, Your Honor. However, the majority decision also, in a few different places, gave us some indications as to what facts would be sufficient to draw that particular inference.
So is that exhaustive?
I'm sorry, Judge, go ahead.
Excuse me.
Is
Is
the
that
list
exhaustive? Are you suggesting that the only thing mentioned by the majority in Zamora, the only basis by which to draw an inference?
No, I don't think the list is exhaustive, but I think what the majority indicated to us is that absent some attempt to apply your remaining earning capacity, we're not going to infer that your continued reduction in earnings is due to your work-related injury. For instance, in the 10th paragraph, the second sentence, the court highlighted the...
Could it be enough that it's an involuntary retirement?
No, the court rejected that. That was the nature of those erroneous Third Department decisions which existed.
The dissent, right?
Well, I understood that differently. I understood the erroneous Third Department cases to be ones that said you must make an inference from that, not that you could make an inference from that.
Correct. That was the Third Department decisions, treated the inference as a presumption.
So do you read Zamora, our decision, as leaving open the question that Judge Rivera just asked, that is, could you make an inference just from the injury?
I don't think so because of some other indications in that decision, and particularly...
You mean dicta?
I wouldn't even say dicta. If you look at the 10th paragraph, the court noted that the claimant must demonstrate that her reduction in earnings is due to her disability as opposed to other factors, such as her general unwillingness to work again. And the court also cited itself, obviously, in the 2007 decision, noting that a central question for the board to address before awarding PPD benefits, permanent partial disability benefits, is whether an attachment to the labor market had been maintained. And in particular, the court highlights now a 99-year-old decision, of course, Jordan v. Decorative Co., where Justice Cardoza outlined two different...
Well, I'm a little confused, because I see the majority. I'm just going to take the moment to quote you. The court says, and it's quoting something else, if the board determines that a workers' compensation claimant has a permanent partial disability, which we all agree is the point here, there's no dispute about this particular claimant in the appeal before us, and that the claimant retired from the claimant's job due to that disability, again, this is an involuntary retirement, there's no dispute about that, correct? Okay, an inference that the claimant's reduced future earnings resulted from the disability may be drawn. I don't see anything else added to that.
Well,
there may be further embellishment to explain some examples, but there's nothing there that says, oh, and by the way, these are necessary prerequisites, and here they are.
I think, yes, on that narrow passage, but if you look at the decision as a whole, and also particularly reliance was put on Justice Carpinello's concurring opinion in Tipping, where he noted a conscious refusal to seek employment after the involuntary retirement would constitute a voluntary retirement of its own. So I think you have to look at the decision of its own. The citation to Burns, the citation to Jordan, the citations to the concurring and dissenting opinions of Carpinello and Cardona to arrive at that conclusion.
So it now sounds like you're making a different interpretation of Zamora than you made in the appellate division, just as a matter of law. In the appellate division, what your brief said is The board, however, is entitled to evaluate the testimony and evidence and determine that this inference may be drawn from the withdrawal depending on the nature of the disability and the nature of the claimant's work. Is that right or wrong?
I trust Your Honor citing inaccurately. That sounds right, yes.
No, and you agree with that position now?
Well, just that when there is evidence, and particularly in this case, it's not as if there's no evidence of a search for work. There's something more than that. There's just a concession from the claimant that she's making no effort whatsoever to apply her residual earning capacity. So it's not as if we have a record that's silent on that particular issue.
But there was a reason for that, wasn't there? Going all the way back to when this whole mess started, going back to the original hearing. And in the original hearing, the ALJ there seemed to be very clear in asking, so are we within Zamora or are we not in Zamora? And it seemed that everyone was saying, no, you're not in Zamora now. And I suppose that if you have someone who's either 81% disabled or 65% disabled, that's a person that's pretty disabled. So it seemed to me when I read it like they were saying, well, this is almost a self-evident conclusion. They asked the questions on cross-examination that you talk about in the original hearing about whether or not she was attached to the labor market. But really, for factual purposes, I think we have to reach all the way back, don't we, to that original finding?
I certainly agree you need to look at the record from the trial hearing. I disagree. I don't think the parties, certainly not the employer, indicated that this case was beyond Zamora. That was a statement of
No, that was a statement of the court. I agree with you. No, you're totally right. No, he didn't. No, the employer didn't say that. The court said that, and the court's an experienced ALJ who looked at this case, and there wasn't much argument on that outside of the attachment questions, which the court allowed him to ask. And I just thought that that's where we get into the may of Zamora, and in other words, the may question. Is this case within it or not? And by that I mean there are certain disabilities that are so clear that it's really not a question as to whether or not there's a possible attachment to the labor market in anything approaching the labor that they were doing beforehand.
Well, Your Honor, I would disagree, but as I see my time's about to expire, I would say in the alternative, this is only an inference. We know it's not a presumption. Inferences fail in the presence of contrary evidence, and that's what we have here, contrary evidence. We have evidence that something other than the claimant's disability is the cause of a reduction in earnings, and that's her unwillingness to work again.
There were several witnesses who gave testimony, I believe, that she was capable of doing certain kinds of work.
Well, there
Is that
was.
what you're talking about?
Well, from the board's finding itself, I don't think that factual finding is in dispute. The board found she had a 65% loss of her earning capacity or 35%
Right, but depending upon the nature of her background and her work, she might or might not be able to do work that was within her capabilities.
Well, that would give rise to another type of claim that wasn't made here. I see my time has expired. May I briefly answer your colleague's question?
Yes, of
Thank you, Your
course.
Honor. That would give rise to something that wasn't raised here, is a total industrial disability, which the courts have recognized as a combination of a high level of partial disability with a sort of non-impressive vocational background that would lead someone who maybe they have the capability to perform light work, they don't speak English, or they're poorly educated, and that's not the facts we have here. We have someone who has an earning capacity, and the board's determined she's had an earning capacity. Thank you.
Thank you, counsel. Counsel?
May it please the court, Patrick Woods on behalf of the Workers' Compensation Board. This is a case where the board messed up.
So, counsel, what would you have us do here? At this stage of the proceedings, what are you asking this court to do?
We're asking you to vacate and remand it to the board, for the board to either apply its administrative precedent or acknowledge its administrative precedent in its decisions and explain why it's not going to follow its administrative precedent.
Would we need to send this to the appellate division, or would we send it back? If we agreed with you, would we send it to the appellate division?
I think as a strictly procedural matter, you may have to send it to the appellate division with instructions to send it back to us. I'm not 100% sure on that as a process question. I don't think that there'd be anything for the appellate division to do as a legal matter beyond that at this stage of the case. I mean, as you know, we had even made a motion to this court to vacate it at this level using Workers' Compensation Law 123.
Can you explain what you mean by that legal phrase, you messed up? Explain to me, what is your understanding of how the board should have applied the law and its precedent and its rules?
Here, the board should have, in making its initial decision and in its two panel decisions, should have acknowledged that it has an administrative precedent about when attachment to the labor market is found. And that's where the claimant has done something to show that they're continuing to be engaged in the labor market, either by, honestly seeking additional employment or participating in a retraining or job placement program. The board's decision here at no level grappled with that.
Okay, I'm sorry, you're going to have to step back. So are you saying that the board's understanding of Zamora and the law is that in every hearing, the claimant, in some way or another, has to show either that they have made an effort to continue using this phrase, attachment to the labor market, or that they are unable to do so, that they must do that initially themselves? Is that the board's position? That's its understanding of Zamora?
The board's understanding of Zamora is a little bit different than the generally applied administrative precedent that it could depart from. So, as a general matter, yes, the claimant would be, it's the claimant's burden and it's their requirement to show that they've made efforts to remain attachment to the labor market.
Is that only if it's raised by the employer?
Yes, that's one of the exceptions I was going to point out, is that an employer can waive that by not raising it.
Okay, so now I've really misunderstood the process.
Okay.
So the claimant has the burden to show the disability, correct?
Correct.
Correct? Burden of production, burden of persuasion. And you're saying that unless the employer disputes the attachment to the labor market, they don't necessarily have to also carry a burden of production and burden of persuasion on that?
It's the same as in any aspect of litigation where if somebody has waived an issue, we're not going to worry about the burden of persuasion and burden of production on that issue because it hasn't been raised, it's been waived, it's been banned.
And how does the employer do that? Simply saying, raising their hand and saying, you have to show that you're not attached to the labor market?
Typically, they'll raise it, as a practical matter, there's generally a series of hearings that happen, and the employer will raise it at one of the hearings, and it'll get resolved at a later hearing in the process.
In the sense that the claimant will then come forward, or not.
Or not.
Will fail to do so, will come forward with whatever evidence the claimant has.
That's correct, Judge.
So, in other words, you presume that they're attached to the labor market unless the employer argues, raises the issue, because you're not saying they have a burden.
We treat the issue as waived unless the employer raises the issue. I'm not sure that it would be right to say that there's a presumption in either direction.
Well, I don't know why it's a waiver. Sounds like a presumption to me.
It's essentially treated as a defense, Judge.
So is there a bright line rule that the board can't infer labor market attachment if the employer puts the attachment in issue? Or is it at that point then there is still some discretion?
I want to make sure that I'm understanding the question correctly. There's not even a bright line, 100% applicable rule that the claimant has to make these efforts. There are circumstances where the board does not require that kind of production, and we've cited one of those in our brief. That's the IBM decision. So, for example, if there's medical evidence saying that they can't go try to be attached to the labor market during that period, the board can draw the inference and won't require them to do so. If you're asking whether the board can sort of ignore this requirement after the carrier has raised it and put it in dispute, it can in that sort of circumstance. Does it have a...
I guess my question is in terms of what your past precedent is, was it a clear line that once the employer raised it, that you couldn't apply the inference?
No, it is not the case that I think either under the board's precedent, definitely not the case under Zamora itself, that we could never apply the inference just because the employer has put the issue into dispute.
Well, then I'm not sure why you're saying this is inconsistent with your prior precedent here.
Because we didn't acknowledge the prior precedent, and on the facts here, there really isn't, there's no showing that she,
As I think you just explained, the prior precedent would allow you to make an inference based on the disability, or here it could be based on the disability plus the retirement.
but the instances where we're not, where we're drawing that inference based on medical evidence or something, those are exceptions to the general rule. And we could, in those circumstances, draw that inference, but we would have to acknowledge the rule, and we would have to explain that we're deviating from the
But
rule.
what is the rule, then? How would you state it?
That, generally speaking, the claimant needs to put forward evidence of attachment to the labor market, and they can do that in one of two ways. They do it by either putting forward evidence of a search for employment within their limitations, or by participating in one of several potential job training or
I just
job
want to be
placement
clear, when you say
programs.
attachment to the labor market, it's at the time that they're seeking the benefit initially.
That, as, right now, post the
Given
2017
the
amendment.
amendment. Yeah.
Yes. The only point at which they need to show attachment to the labor market post the 2017 amendment is at the time that they're classified. They don't no longer need to show it on an ongoing basis so long as they were entitled to it, to an award at the time at which they were classified.
So if I'm understanding your rule, this part of Zamora that I had quoted previously, that you can draw the inference, the claimant, based on the fact the claimant retired from the claimant's job due to that disability. That is actually not what your rule means.
No, Judge, and if I could point you to a slightly further up place in Zamora.
Okay, that's fine.
By finding alternative work consistent with his or her physical limitations, or at least showing reasonable efforts at finding such work, the claimant can prove to the board that the cause of his or her reduced income is a disability rather than an unwillingness to work again. What the
Sure,
rule-
but I'm not asking you about that. No, that's not in dispute. I'm asking you about this. It says you can infer this
Yes.
inability as opposed to unwillingness to work from, again, the fact that it's an involuntary retirement and the nature of the disability, right? You're
Certainly-
saying you no longer do that.
No, I'm saying that the precedent is that we don't do it, generally speaking. And if
The
we're going
don't
to
do it
depart
is
from-
you don't make the inference, right?
Right, and if we're going to depart from that, we have to explain it. The board absolutely has authority, and this is a point where we disagree with the appellant. The board has the authority under Zamora to draw that inference, but if it's going to do so, it needs to explain that it's departing from its usual practice when it does so.
Do you have a prior precedent in which somebody was granted disability retirement and then subsequently determined not to be essentially disabled?
Not to be disabled or not to be attached to the labor
Well,
market?
not to be attached.
Okay. I'll give you two.
Okay.
One from before this decision here is Metropolitan Hospital Center. That's 2014 NYWCLR Paran LRP Lexus 112. That's a 2014 decision. The second one is Deer Park Union Free School District. I have that as New York Workers' Comp Lexus 567. That's a 2018
Are there,
decision. We have, in several cases, found that there's an involuntary retirement, but then also found that they're not attached to the labor market.
any set of facts where it would be error as a matter of law for the board to give the claimant an inference of labor market attachment?
I think there's probably an outside case where it might be an abuse of discretion, because it's in the board's fact-finding discretion to whether or not to draw that inference under Zamora or not.
So if I'm understanding your rule, please correct me because I'm genuinely confused now. If I'm understanding your rule, despite the fact, and I'm not going to quote it again, the language from Zamora, the board's position is that it will not draw this inference when it comes to certain kinds of disabilities, the combination of certain kinds of disabilities and the work, the former employment. But there are just some of those where one would never draw the inference, and you've already drawn that line.
I think the board's precedent is that for the vast majority of cases, there
Yes.
needs to be a demonstration of willingness to work.
Okay, so flipping that now, if I'm understanding you, is that you all have interpreted Zamora as meaning there are a very, very small class that ever fits the language that I've quoted.
I believe that's correct, Judge.
Okay,
Certainly
and
one that would work.
is that based on the board's experience? Where do you come to that conclusion? Because you obviously didn't go through a rulemaking process, so where do you get to that?
Well, if I could,
Yes, please.
one of the things I want to, right off the bat, one of the problems with the procedural posture that we're in right now is that a concern about the rulemaking, for example, wasn't in part of this record at any point before we got to the responding brief, to our responding brief in this court. So there isn't a record that I can point to you at for that decision-making process. That's part of the reason that we made the motion seeking to vacate it and have it go back, so that that kind of argument, if claimant wanted to make it, she could make in the first instance before the board and before the third department, and there could be appropriate stuff in the record to show that.
Yeah, but you're arguing to send it back on the presumption that indeed it is valid, that it is inconsistent, it's already a valid determination you've made, so I'm not so sure I'm persuaded by that argument. But again, could you please try and answer this question, if you can. If you can't, I understand the prior question about whether or not, what's the basis for the board's apparent determination that under Zamora, there's a small class of claimants for which you could make the inference that Zamora is referring to.
I mean,
As opposed to doing it on a case-by-case. You sort of already know there's a very small class.
I think it's just the board's administrative precedents have grown up as requiring in the first instance absence and some additional exception, attachment to the labor market. And the board's precedents for that, in fact, they predate Zamora, and they were applied to the involuntary retirement context after Zamora.
I just wanted to ask you one more thing about the board's precedents. And I may have misread some of these, but some of the precedents you cited, I'm thinking of Shriver Pavilion, Solon Packing, Compass Group, JD Consulting. As I read them, dealt with temporary disabilities, not partial permanent disabilities. Is the rule the same?
The general labor market attachment rule is the same. And
You don't apply it differently for a temporary as to a permanent?
You still need to show willingness to work in order to be able to, unless it's excused for some reason.
Thank you, counsel. Counsel?
May it please the court, Robert Gray on behalf of the claimant respondent.
So why shouldn't we just send it back? Since they says they messed up.
The outcome that the board and the appellate division reached here is correct. Each of them may have gotten the reasoning for that outcome wrong in different ways, but the outcome is correct. If I can pick up on the end of the last argument about the board's precedence on this issue going back before Zamora and to Zamora and then to date. The fact of the matter is that beginning in the mid-1990s, the board determined that it wanted to add to the workers' compensation law the unemployment insurance law concept that in order to be eligible for benefits, you must demonstrate attachment to the labor market. The court's aware that that provision is not in the workers' compensation law, it's in the uninsurance law. The board now admits in its brief in this case that it took the concept from unemployment.
Is that being challenged? I mean, my understanding, my reading of what happened here is that the board sort of didn't say anything about the attachment issue, just said that she had involuntarily retired and went past that. And then we get this confusion about the 2017 amendment, which, if I'm correct, everybody agrees, and correct me if I'm wrong, applies to after a person is found qualified for benefits, not before. So I think we put that out of the way. So it seems to me that that's what that the board is basically saying. we didn't do what we usually do here. We just sort of went past that question, and we don't usually base it just on the fact of involuntary retirement when the issue has been raised about attachment, and that's how we goofed, right? Isn't that how we got here, really? And they want to say, now let us go back and decide whether we should apply the inference or not. We never made that determination.
That's not what they're saying, Your
No?
Honor.
Okay.
That's not at all what they're saying. The employer's position here is that Zamora says the board can't extend the inference to an injured worker, which is plainly not what the case says, and I don't think, unless the court has questions about that position, that I need to address that one further. The board's position
Can't do it
is...
just based on involuntary retirement. I think that's what they're saying. It's a separate issue.
Well, they express it different ways in their brief and an oral argument. In some places, they say that Zamora says the board can't extend the inference without proving labor market attachment, in which event there is no inference. It's circular logic. So fundamentally, what their argument boils down to is anytime the worker is partially disabled, regardless of the reasons why they left work, if we say, are you looking for work, the obligation immediately springs into existence for the worker to demonstrate that they're attached to the labor market, or, and it's important for the court to understand this, they get no benefits. So fundamentally, what this argument does is it transforms this law from one in which we have total disability and partial disability and no disability to one where we have total disability or nothing. The result of an injured worker being found unattached to the labor market is that regardless of the extent of their partial disability, they do not receive benefits.
Well, no,
Well, I
That's
thought
why-
the argument is they have to
excuse me.
show that it's, the reason they're unattached has to be the disability.
so they may have a 65% disability, and with that 65% disability, they may be able to work consistent with their limitations, or they may not be able to work consistent with their limitations, depending upon a lot of other factors. That's how I see it. That the rule has always been, or at least for quite a while now, has been you have to show involuntary retirement and attachment unless you can't attach.
If I can address Judge Rivera's question and then lead into your question, whether the separation from employment is related to the disability or unrelated to the disability, up until Zamora, was always treated as a trigger for the question of what the injured worker's obligation was. If the worker left employment because they were hurt and they weren't able to go back to that job, then we inferred that they were entitled to benefits and the worker had no further burden of proof or obligation. On the other hand, if the worker, as in the Jordan case, went back to work at full earnings notwithstanding their disability, and then quit or got terminated, and then wanted to claim benefits after there was a clear break in the chain of causation between the injury and the loss of wages, then they had a burden of proof.
That's the ongoing versus the initial qualification for benefits initially versus ongoing attachment. And so I'm not sure whether you agree that attachment is even an issue when you're first applying for benefits.
I can tell you that the employer's position and the board's position is that as soon as at any point in the case, there's evidence that the worker has a partial disability, as of that date, that worker has an obligation to demonstrate attachment to the labor market. That's what they're telling you, is once there's evidence in the case of partial disability, if the employer raises the issue, the board will require the injured worker to produce that proof.
Except for the amendment now says that once you get past that initial hurdle, then you don't have to continue to show that.
Right, well, this is the point.
Of course, excuse me, the logic, Judge Stein's point is a good one because it goes to the logic of the attachment to the labor market caveat that's been placed in the law, that's not in the statute as far as I can find it, one way or the other. And it seems to say that when the worker is, of course, most injured and most sick right after something happens to somebody. They fall, they herniations, whatever. That's when they're supposed to be attached to the labor market now. And that finally, up to when you're classified. And then now, after the 2017 amendments, post-classification, you don't have to show attachment to the labor market. Do I have that sequence correct?
Your Honor, if I can attack that this way.
Okay.
If you go back and look at the Zamora case, which obviously the court has, the Zamora case was a permanent partial disability case. Zamora was a case where the lady was declared permanently partially disabled, then subsequently stopped work. There was a question of fact as to whether her separation from employment at that point was voluntary or involuntary. The board found that it was involuntary, but nonetheless required her to look for work.
Right.
And the court said, contrary to 60 years of cases prior to that, going back to Roberts versus General Electric, that, okay, under these circumstances, you may require a permanently partially disabled worker to look for work after classification. The
Right. So my
legislature's
question
overruled
is-
that.
But my question is now, today.
Right.
Is the rule, when you're most injured, is when you're supposed to be showing attachment to the labor market?
So the legislature has expressly eliminated the one requirement that Zamora created, which is that if you're permanently partially
You got this
disabled, you have to
divide,
look for work.
classification.
So-
One side, the legislature's eliminated attachment to the labor market. Pre-classification, you still have to show it.
Well, so now what's happening in this case, and why we're here, is the employer wants to take now that requirement, which was overruled for permanent partial disabilities, add it to the class of temporary disabilities, and expand it so that it's a rule that the injured worker must look for work,
You refer to
and
them
the
as
board
temporary.
cannot infer.
Let me stop you. You're referring to, for the court, for all of us, so you're referring to them as temporary disabilities. That's the time period from when the injury took place to when the classification takes place? Is that what you're saying?
Yes, from the date of the
All right.
accident to the date
All
of
right.
classification, which, by the way,
Let me
Your
just
Honor,
ask this question then. So are there cases where someone is so disabled, they're permanently partially disabled, but they're so disabled that that a court would look at that and say, it's self-evident that this person cannot go forward and be attached to the labor market in any meaningful way, because of their age, their physical condition, other factors, in this case, diabetes, things like that. Are there cases like that?
if I can answer that, Your Honor, in two parts.
Okay.
On the temporary disability piece, it makes less sense to require labor market attachment during a period of temporary disability, because during that point in time, the worker has some expectation that perhaps they'll get better and they'll return to full work. So it doesn't make logical sense to make them look for other work.
All right,
With
and did that
regard-
happen here?
Pardon?
Did that happen here? This worker did attempt to go back to work, the way I understood it.
This lady, after she got hurt, tried to go back to the employer, tried to do her job, asked the employer for an accommodation, and only left employment when the employer refused to give her an accommodation and approved her disability retirement. I know my time's
So she
expired.
claims she was placed in a job that created more physical strain than the job where she was injured.
Yes, the employer seems to have transferred her.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Your Honors, if I may, I think the simplest way to look at this is to look at the difference between someone who is involuntarily ceased working and someone who's voluntarily ceased working. An individual who is in, it's our position, who's involuntarily ceased working, stopped working because of their disability, may be entitled to that inference if they demonstrate some continued willingness to work, such as by looking for work and presenting that to the board. A claimant who voluntarily ceases working, even if they search for work, the board will not infer that the reason they cannot obtain equally well-paying work is due to their disability.
I didn't think that was the case here, though. Maybe I'm wrong. I thought this was an involuntary.
It is, but what I
All
want
right,
to highlight...
so the kind of the onerous implication of someone who's voluntarily ceased working doesn't really apply here.
Well, I think it's helpful to look at that situation, and in our brief is the appellate division's decision in Reese. Even that person who ceases working for reasons unrelated to their disability, and then looks for work, and then even finds light-duty work, the board will not conclude that that individual's reduction in earnings is due to their disability. That person must show the reason they cannot obtain equally well-paying work is because of their disability.
Yeah, let me just, for clarification, I'm very confused now. So let's take the example now with the amendment. Once someone has been classified as PPD, you agree that moving forward, they no longer have an obligation to show an attachment to the labor market, correct?
Assuming they were...
Okay, no, once they're classified.
Yes, if I could add a
classified,
caveat. but
PPD.
yes.
No, I know where you're going. That's the second part of the
Sure.
question. Okay. What is your position with respect to whether or not they have to show that they either cannot work or that they could work and that they have tried to find work but were unsuccessful before the classification? Do they have to do that to be classified?
In order,
as
no,
PPD.
and Ms. Zamora was classified at a time she was working at full duty. So there's no, the board will classify someone with a permanent partial disability regardless of whether they're working, not trying to work, et cetera. It's just the finding that the disability is matured. It's at a stage where we know it's not going to substantially change.
Okay. All right, so then if in this case, how would, your understanding of the rule, how should it have worked?
It should have worked, as everyone agrees the claimant left her work because of her disability. But she needs to...
Involuntary retirement.
Correct. Well,
You also don't challenge that there is a disability.
no, there's certainly a disability. At all stages, there's evidence of a partial disability that are relevant to this case.
Yes.
How it should have worked is that she should have made some showing that she had a continued willingness to work. And based
When
on...
is there, at some point, what point is that?
Well, before classification, and in this case, there were several years of awards that were addressed all at that September 2015.
In order to be classified?
There's
Are you
no-
saying are you saying that's criteria to
No.
be classified?
An individual can be classified with a permanent partial disability regardless of whether they're working, looking for work, or just sitting at home making no attempts to work. That's purely a medical question. Has your disability matured to a level where we don't think it's going to change substantially?
Thank you,
All
Counsel.
right, thank you, Your Honor.